Well, hello and welcome back. Employment Law Show. John Scholes along with Lior Samfiru. Anytime you want to check in and contact 1-855-821-5900, help@employmentlawyer.ca. And for the next little while, a website you can always use, covidrights.ca. Coming up on the show today, 5 things you need to know when being recalled from a temporary layoff, because that's going to start happening as well. We'll get to some phone calls from our live radio show and deal with the Pocket Employment Lawyer website as well. Lots of stuff to get through, but my brother, we always start with the week that was. How are you?
Hey, John. Good to be back here. Good to see you, even virtually or remotely. Hopefully before too long, you and I could be back in the same studio, but for now, we're going to take the precautions. But it doesn't mean that we're not here to talk about the exact same things we always do, because there's so many questions, so many issues dealing with employment law and workplace rights, your rights on the job. And these issues are more important now than ever. You know, in the past few weeks, we were talking about what happens if you were laid off. Well, right now, the questions change a bit. Well, what happens if I'm called back to work? Do I have to go back? On what terms? So we're going to address that and many other issues. And remember the rule. If you now, as a result of this situation, if you lost your job, you have significant termination entitlements. In fact, they're greater now than they ever have been before. That's why it's so important now, more than ever, to get that advice if you lost your job, if you're not sure what to do, what your rights are, about anything at all to do with your job. We'll give you my contact information throughout the show, phone, email. You can call, you can send a message. I will connect with you. I'll answer those questions. Don't be bashful. I want to do that. I want to solve those problems. But let me tell you about a situation that came across my desk a couple of days ago, John. This one involved a gentleman. He was called back to work after he'd been on layoff for about 6 weeks. And the problem with this particular person is that he had severe asthma. In addition to that, he has a heart condition. And he told me that if I go to work and I catch the virus, God forbid, that's it. I'm probably not going to survive this thing. At least that's what my doctor tells me. So he did the right thing, and he went to his doctor, and he got a doctor's note telling him, no, this person should not be working. He gave that note to his employer, but his employer said, well, no, government says we're allowed to open. Government says we're allowed to call you back. So if you're not going to come back to work, we're going to consider you to have resigned from your job. So that's when he called me. So here's how this works. The company is right halfway in the sense that if there's work for you and your employer calls you back to work, you are expected to go back, despite the fact that you may have some concerns about health, about safety, about the virus generally. But he had a doctor's note. He had a medical condition where his doctor said, no, you should not be working. So the same rules apply now, and as they always do, which is if you have a doctor saying that you cannot work, you're allowed to be off work, and your employer can't fire you because of it. Your employer can't consider you to have resigned. You're allowed to be off work, in fact, as long as you need to. Maybe it's a week, maybe it's a month, maybe it's a year or more. You can be off work. So this employer is wrong. And I'm going to remind his employer of its legal obligations, but I wanted to also remind everyone watching the show today that if you do have a medical condition that prevents you, at least according to your doctor, to continue working or to go back to work if you're being recalled, get that doctor's note and give it to your employer. If you simply decide on your own, you don't want to go to work, you're not feeling safe, that's not good enough, then you may be considered to have resigned. So get that doctor's note. And if you're not sure how to do it or what your rights are, what to say to your employer, reach out to me. Happy to talk to you.
And this whole business with the employer saying, we're going to consider you to have resigned, that's not a resignation at all. That's a termination. He didn't resign. The company did it for him, or tried to anyway, right?
Absolutely. Now, if he simply had said, you know what, I don't want to come in, I'd rather stay home and not go to work, well, that is a resignation. If you decide not to go to work, you've resigned. But in this case, given the fact that he was following his doctor's advice, he's allowed to do that. So that's not a resignation. That is a termination. So it's certainly something that entitles him to severance, and it's potentially also a human rights violation. So it's wrong for an employer to disregard what a doctor says.
You want to go to employmentlawyer.ca anytime. There you will find links to our radio show, and it's been going on for about eight plus years now, so we got tons of content up there for you to listen to, of course, and we get phone calls on the weekly shows across the country. We play them back here. We talk about we cherry pick the good ones, well, not the good ones, but the interesting ones anyway. They're all good, and we like to talk about them here. The first call for today's show, Lior, is coming up right now.
I'm in a position of management and had a salary plus a commission base. We sort of downsized and we got switched over to do commissions direct. I'm no longer getting the salary that I was accustomed to, and I've been forced into a straight commission-based pay. And I'm wondering if that is a breach of my contract that I have with them.
How long have you worked for this company?
Just over 2 years.
How old are you?
I'm 53.
Yeah, this is something that I see often, and this is not just a COVID issue. What I'm going to say now applies in all situations. If you're working and you're getting paid a salary, and now the company wants to put you on commission, that is a big change. If you're on commission and the company wants to take away the commission and just put you on salary, that's a big change. And whenever we're talking about a big change, we have to have the words constructive dismissal in our minds. An employer does not have a right to make big changes, significant changes to the terms of employment. So for this person, going from salary plus commission to 100% commission is a big change to the terms of his employment, and his employer does not have a right to make a change like that. Now, the fact that I said that his employer doesn't have a right to do it doesn't mean that there's a way to physically stop the company from doing it. We can go in there with a baseball bat and threaten them. All that means is now this employee has a choice to make. He can choose to accept this change, and now he's 100% commission, or he can choose to treat that as a termination of his employment, also known as a constructive dismissal, and get his severance. That are his options. Now, let's find out how much severance he's actually owed, just so that we have a complete sense of the situation. So let's plug his information to pocketemploymentlawyer.ca and see what he's owed. So you see on the screen, he's a manager. He's been there for 2 years. He's 53 years old. If he chooses to treat this as a termination, he'd be owed right around 6 months' pay. Now, depending on what his income is, in this case, I use a number, let's say it's $91,000. You can do the math. It's a significant amount. So that's why it's so important to understand that your changes to compensation, your changes to your compensation structure is not something your employer is allowed to do. It gives rise to a constructive dismissal. And Pocket Employment Lawyer is your friend to determine what you're owed and how much you're owed.
What did this gentleman figure? You know what? I really love this job. I really don't want to leave it. I've done well here, but they're changing the pay structure on him. Can he, as we like to say in the show, take it out for a spin for a month, 2 months, and see if it actually evens out money-wise, and then say, you know what, it's not working for me. Now I'm going to get out of here. Can he do that? And should he do it in writing?
Yeah, well, he can try it to the extent that he's not sure how that's going to impact him. He can. He doesn't have to. Even, by the way, John, just so you know, even if it means he's going to be making the same money potentially, that's still a constructive dismissal given the change. But if he wants to try it, he can. And what I would recommend that he do is tell his employer, I have concerns, in writing, by the way. I have some concerns. I'm not sure if I'm agreeable to this, but I'm going to try it over the next 6 weeks and see how things go. And then I'll let you know if I'm okay with this long term. If he puts that in writing, that's okay. And after 6 weeks, then he can decide whether he wants to continue or treat that as a constructive dismissal. You usually would have 4, 5, 6 weeks to do that, but make sure you put that in writing.
Again, reaching out anytime, 1-855-821-5900. Email is help@employmentlawyer.ca. I want to read an email here that we got, and I know you want to combine this with Pocket Employment Lawyer because it's pretty interesting. Seth writes in and says, guys, I've been working as an independent contractor for the same company for 5 years. I was just laid off due to COVID-19, but not given 60 days notice that was agreed upon in the original contract I signed. Says, I don't believe my employer has any intention of giving me more work. What are my rights?
Well, here's the thing. The first issue here we want to determine is whether he's an employee or an independent contractor, okay? That's the key issue here, because if he is an employee, if the law determines him to be an employee, then he has an entire host of entitlements under our laws, under employment laws, whereas an independent contractor, he wouldn't. This is a very common situation. If he's been there for a number of years, he is likely an employee. That means he's owed severance if he's now going to be out of a job. Now, especially now when we're dealing with the COVID situation, I've seen many quote-unquote independent contractors being terminated, being let go, and company says to them, well, we don't have to pay you anything because you're not an employee. Wrong. In most of these situations, the individual is actually misclassified, just like this person whose email you read. And because of that, they have the same termination entitlements as any other employee. If you have a regular job, you are an employee. It doesn't matter what you call yourself. It doesn't matter what document you sign. It doesn't even matter how you pay your taxes. If you have a regular job, you are an employee. So remember, for this person, yes, he can go, by the way, also to pocketemploymentlawyer.ca. We have a tool there that allows you to determine whether, in fact, you're an employee or an independent contractor. So if you're not sure, just go to pocketemploymentlawyer.ca, answer a few questions, and you'll find out, oh, wait a second, I'm actually an employee, or maybe I'm not. So that's how easy it is to use that. Takes seconds. And this question, are you an employee or are you an independent contractor, has never been more important than now when so many people are losing their job.
Well, I mean, we've been saying for years on this show and the radio show as well, if it was just that simple to be an independent contractor, everybody on the planet would do it because there would be no obligation for severance. You wouldn't have to pay benefits. You wouldn't have any bonus, all that stuff. It'd be so much easier. Not the case. Not the case.
Not the case. It's very easy to misclassify someone. But if it was that easy to change your legal status, no one would ever be an employee. We wouldn't have employment rights. You and I wouldn't be doing shows for years and years. There could be no point of that. So no, the law decides. The law is the only one that decides if you're an employee or an independent contractor. And again, to find out for yourself, just go to pocketemploymentlawyer.ca.
You bet. Coming up here after a short break, the 5 things you need to remember when being recalled from a temporary layoff. We'll tackle that after a short break. 1-855-821-5900 and employmentlawyer.ca as well. Don't go anywhere. We'll come right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. You know, it's interesting, Lior, as we do this show and have been for years, the transformation from, say, 6-7 weeks ago to telling people, everybody, what they need to know when they get laid off due to COVID-19. And now we've almost come full circle where we're going to let people know what to do when they come back from a layoff from COVID-19 or otherwise. So it's really interesting how the law has really not changed, but how we've seen different aspects of the law because of this pandemic, right?
And remember, the law is the law. The law hasn't changed, right. Will not change. So your rights are the same. We just need to understand how to apply them in these situations. So we want to spend a few minutes talking about how the law applies and what your legal rights are when you're called back to work, if you're not called back to work. And John, nothing will make me happier, hopefully in a few weeks, if we never have to utter the word COVID again.
Yeah, no kidding, right? No kidding. So we'll get to those at least 5 talking points anyway. What you got to know when you're being called back from a temporary layoff. Number 1 is this, brother, that you have a right to return to a safe workplace. That's huge. That's huge.
That is huge, and that is the first thing that we need to talk about. That is a fundamental duty that an employer has, is to provide a safe work environment. That it's a fundamental right that every employee has to work in a safe work environment. That's so important. That's fundamental. It's always been the case, and it's certainly important more than ever right now. So for your employer's standpoint, your employer has to make sure that it follows each and every one of the guidelines and the regulation that the government puts forward in terms of reopening the business, whether it's social distancing, whether it's controlling the number of employees or customers, whether it's having dividers, whatever it is, whatever the government says you have to do, the employer must do it. If there's a cost and they don't want to pay the cost, well, then they can't open. It's that simple. They have to follow what the government does. Now, if the government does that, the employee is expected to go back to work. But if the employer doesn't do that, you're allowed to refuse work. You don't have to work, and you can't be punished. So an employer, it's a good idea to tell your employees, here's what I've done. Here's the measures that I've implemented. Here's why you shouldn't be as concerned to come into work. Remember, you can also ask questions of your employer. Did you implement these measures? Is there anything else that needs to be done? You have a right to not only go to work, environment that's safe, but to also know what the employer has done to make it safe.
All right, you're coming back from a temporary layoff. Something else you need to know: when you come back, you are owed the same job, the same pay, same hours of work you had when you left, right?
Exactly. The employer's fundamental obligation is to take the employee back on the same terms of employment. So same salary, same benefits, same bonus structure, same hours. Now, in some situations, and we've heard a lot of stories, certainly I have over the past couple of weeks, where the employers say, well, we'll bring you back, but we'll only pay you 50% or 75%. Well, even in those situations, remember, the law still applies, meaning if you're coming back from a temporary layoff and your employer is going to reduce your pay, you now have that famous choice, which is, do you treat that as a termination, constructive dismissal, and require the company to pay you severance, or do you accept and continue working? My concern with accepting it is that by accepting it, there's no guarantee that they'll increase it back. So maybe now you're stuck making 50% or 75% forever. So if you are going to accept the change to the terms of employment, please make sure you send the employer a note. An email works great, saying, employer, I'm accepting this now because of COVID, but I'm expecting to go back to my usual salary as soon as possible, and I'm not agreeing to it permanently. Put that in writing in an email. And if you don't do that, you're not protected. But keep in mind that right off the bat, even without that email, you may have the right to treat that pay reduction, the reduction in hours, to treat that as a constructive dismissal.
Third one is this, and we've actually had this one come up on the radio show a couple times on the phones, and that is, when you go back, you do not have to sign a new employment agreement. They're trying.
Absolutely. No, they are. And I've had at least a dozen people over the past week alone contact me saying, well, my employer says I can come back, but here's an employment agreement they want me to sign. Bad idea, bad news. You should not ever have to sign a new employment agreement if you're already employed. Certainly not when you come back from a temporary layoff. The only reason an employer would want an existing employee to sign a new employment agreement is if it provides for better terms than what the employee had before for the employer. It's better for the employer. So no, it could potentially take away your severance rights. It could potentially give the company the right to change your job in a way that they wouldn't have a right before to do. So if your employer wants you to sign a new employment agreement, you can first of all ask why, but you can also say thanks, but no thanks. There's nothing they can do to punish you. And if you're not sure whether you should be concerned what the new agreement says, send me a copy. You can just email it to me. Let me review it and tell you what is in it that should concern you. But no, you should not have to sign a new employment agreement just because you're coming back from a temporary layoff.
That email address, by the way, help@employmentlawyer.ca. Number 4 here, we're talking about the points, things you need to know when you're being called back from a temporary layoff. And this one, just as important, your seniority, even though your employer might try, does not go back to 0 when you walk through the door after that layoff.
I've been asked that question a number of times, so I wanted to bring it up here today. When you come back from a temporary layoff, when you resume employment, you've resumed employment, right? You're not starting again. You're not starting from 0. So your seniority is continuous. Not only that, the time that you spent on a temporary layoff, whether it's 2 months or 5 months, however long you've been, that time does count towards your seniority. Now, why is that important? It's important because if down the road your employer lets you go, the more seniority you have, the more severance you're owed. So remember, you don't lose your seniority just because you signed or just because you started a new job or because you returned to your job from a temporary layoff. But keep in mind, your employer can eliminate some of your seniority with an employment agreement. So just as I said before, you don't want to sign that employment agreement because it potentially could cost you a lot of money in your future severance if your employer is trying to get rid of your seniority. So please don't do that.
And this last one I'm going to throw at you, possibly the most important one. If you are not called back in the first place, you are owed severance.
We've talked about what happens if you're called back from a temporary layoff. Unfortunately, a lot of people are not going to get called back only because an employer may be cutting costs, may be restructuring, and there may not be a job for you. Well, if that is the case, remember, you are owed severance. And it's not a week's pay per year or 2 weeks' pay. It's significantly more. Now, not only is pretty much in every situation you're owed much more than your employer is offering you, that's especially true right now. Because of the fact that it's more difficult now to find a new job, given the fact that so many people have lost their jobs, companies are not hiring, because of that fact, you're actually owed even more severance than you'd normally be owed. So important to get that advice. I've seen situations where an employee is told, I'm going to give you 6 weeks pay, and that employee is owed 9, 10 months pay. Just recently, a few days ago. Don't let that happen to you. Make sure you know what you're owed. PocketEmploymentLawyer.ca has a severance calculator feature. You can find out in seconds. And maybe you're sitting at home right now wondering, hey, I wonder if they're going to call me back or if I'm going to get severance. Well, go to PocketEmploymentLawyer.ca. Do the calculation. Again, take seconds so that you know how much you should be getting if the company does let you go. And if you're staring at that severance letter right now, let's talk about that. Do not sign it without speaking to me first.
The website, by the way, employmentlawyer.ca. Go there anytime. You can catch our long-running radio show. We'll get to phone call number 2 from the radio show right now, pal.
So prior to when the CRB came into effect, I was on regular EI because my situation involved myself getting off work because of having COVID symptoms. They were not satisfied with the medical note that I provided, so they actually terminated me while I was on sick leave.
Yeah, well, where do I start with that, Johnny? I started off the show by saying that if you have a doctor's note, that is your protection, and that is 100% true. You cannot be fired because you're on a medical leave that your doctor has approved. That's illegal. Not only is that a wrongful dismissal, but that could easily also be a human rights violation. No, you can't be. So if that's why this person was let go, if that's why the company decided that he's not going to work there because they didn't believe his doctor or they thought his doctor's note was not good enough, nonsense. They cannot let him go because of that. Now, if a company thinks that the doctor's note is ambiguous or that the doctor's note is not clear, they can ask for more information. Can you clarify? Can you tell us how long you expect this person to be off work? Is there something that we can do to accommodate this person? They can ask those questions. But they can't say, well, we don't like this note, so too bad, you're out of here. No, that's wrong. That's illegal. So this person potentially has human rights entitlements. They certainly have severance entitlements. And same with you at home. If you lost your job because your employer doesn't believe your doctor, that's wrong. That's illegal. You have significant entitlements. You really want to pick up the phone or send an email as soon as possible.
An interesting sidebar to that point, which I don't think we've talked about in a while, is an employer is allowed to ask about prognosis, not diagnosis, correct?
Absolutely. Your employer cannot ask you what your medical condition is, okay? Your employer can ask, how long are you going to be off? What limitations do you have? They can even ask, when are you going to be evaluated again? But whether or not you have a bad back or you suffer from anxiety and depression doesn't really matter. Your ability to work is what matters, not the reason for that inability to work. So your employer can ask you prognosis, not diagnosis, not what your condition is, what medication you're taking. That is off limits. Your employer does not have a right to ask that, and you certainly should not be giving your employer that information.
All right, coming up here after a break, the impact of COVID-19 on severance pay. We will tackle that when we come back. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And right back at employmentlawyer.ca is where you want to go to find our long-running radio show. You can tune into that each week, and we play the phone calls from that show back here. Third call from the day. Lior is coming up right now.
I'm a 30-year employee where I am. I'm on a temp layoff. before COVID, and I'm wondering if I don't end up getting asked back, do you guys see them cutting, like the courts actually starting to cut what they're giving people? My understanding is I would be due about 2 years according to the calculator you guys have online, and I have two friends who were both just let go by the company. When they were let go, they were both as well 30-year employees. They both got in the region of 52 to 56 weeks, my understanding.
In the calculator we trust. In the calculator we trust, right?
We trust in the calculator. We trust in the law. Here's the thing. The question is, well, because of this current situation, can we expect severance amounts to be reduced? Can we expect the courts to say employees should pay less severance? No, not even close. In fact, the opposite is true. I alluded to that earlier on the show. Not only do your severance entitlements don't get reduced because of COVID, they increase. And they increase for one simple reason. It's going to take you longer to find another job. And that fact is a huge factor that allows that makes it so that now you're getting more or owed more severance. So those individuals that this caller mentioned that worked for 30 years and got 52, 56 weeks pay, that's a wrongful dismissal. They've been given about a year's pay when they should have gotten 2 years pay. So no, you can't assume ever that what you've been offered is appropriate. Even if you think that it is, hey, double check. It's your life, it's your money, it's your livelihood that's at stake. Go to pocketemploymentlawyer.ca. It takes seconds. It's free. It's anonymous. You don't even have to do anything other than just pick up your smartphone, your tablet, your desktop, whatever it is, and you find out, and then you don't have to wonder anymore. Pocketemploymentlawyer.ca. But COVID doesn't mean less severance. If anything, it means more severance.
Another place for you to ask questions anytime, get some answers, terminationquestions.com. We'll get to one of these with the remaining time. This one courtesy of Cassie. Cassie says, for the past 3 years, I've received a bonus at the start of each summer. My manager told me they are ending it due to COVID-19, even though I met all the goals. They also said they can no longer give me overtime pay. These two changes are a big hit to my income. What do you think?
Well, John, it's that last sentence that's key. So the fact that no overtime and no bonus, it's a big hit. Now, I would want to get some more information. What's a big hit? Some people may say that 3% is a big hit, and I get it. But the reality is for it to be a big hit in the eyes of the law, the impact has to be more than 10% over your total compensation. So an employer does not have a right to change compensation by more than 10%. That doesn't mean that they have to reduce the salary. That means that any changes to the compensation. So if now they eliminate the bonus, and because of that, that's more than a 10%. Or maybe now you're not getting paid overtime that you usually used to get. Now that's a 10% decrease to your compensation. That also is a constructive dismissal. It's something that the employer is not allowed to do unilaterally. So this person, she has a choice to make. We touched on that before. She can accept this new reality, and now she's working with no overtime and no bonus. That is obviously, it's her right, it's her job. Or she can simply treat that as a termination and say, employer, I'm not agreeing to this. So if you do it anyway, just so you know, I'm going to treat this as a termination and require you to pay me my severance. Absolutely well within her rights to do that. And then if you do want to do that, if you're ever in that situation, your compensation has changed. A lot of employers, by the way, are eliminating bonuses and other perks. If you're in that situation, before you tell your employer, that's it, no, I'm out of here, before you quit, before you even utter the words constructive dismissal, let's you and I talk first so that we can do it right, so that we protect your rights. But that is always an option that you have if your compensation has been affected.
And we all know what happens if she does accept it down the road. Could be bad news.
Well, now it's a change to bonus. Well, if she accepts it, now she's opened the door to arguments. Maybe now, next time, it's a change to her benefits. Maybe it's a change to her commissions or her pay structure. So you don't want to open that door a bit, because then the employer can knock it down completely, and that is a big, big problem.
We are done for another day. You want to reach out now? It's really simple. 1-855-821-5900. You can always use pocketemploymentlawyer.ca. The email address we use is help@employmentlawyer.ca. That is the main website. That is the source to catch the radio shows as well. Hope you enjoyed everything here. And for the next little while, you can also go to covidrights.ca as well. We'll catch you next time right here, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.